Okay, hi everyone. Bonjour à tous. Thanks for joining us for this session about patent rights in space. My name is Jérôme Lafrenière. I'm Director of IP at NGen. NGen is Canada's global innovation cluster for advanced manufacturing. I have the pleasure of being alongside Jay Millman. He's a patent agent and partner at Aird McBurney. Thank you, Jay, for joining us.
Thank you.
And before we jump in, allow me to briefly introduce NGen and provide a bit of background for today's session. Next slide, please. So NGen's purpose is building advanced manufacturing capabilities for the benefit of Canadians. And we accomplish this in three ways. The first one consists in what we call ecosystem initiatives, which are programs designed to help Canadian manufacturers and workers to face the challenges imposed by the fast transforming manufacturing industry. And the second one is our cluster acceleration program, in which we help manufacturing related clusters across the country to develop and deploy their own initiatives. And our third driver is our funding program, in which we provide financial and advisory support to companies as they conduct advanced manufacturing development projects, such that these projects go further or materialize quicker than they would have otherwise. Next slide, please. And one of these programs is called Moonshot for Mining, Minerals, and Manufacturing. This one was supported by the Canadian Space Agency and Innovation, Science, and Economic Development Canada. As you can see from the slide, the space industry is expected to grow by $1 trillion over just 2 decades, and companies around the world are racing to secure and grow their share. So NGen launched its Moonshot program to support Canadian companies and specifically those that are active in the field in terms of in-situ resource utilization. And to give you a flavor, some of the projects that we funded include manufacturing of nanomaterials that are doped with rare elements, deployment of unmanned vehicle fleets for the mining and construction projects on the moon and on Earth, and also characterization of critical mineral reserves. So that's just to name a few. So we're not talking about niche science experiments on the ISS. We're really talking about industrial scale programs with near-term applications. And in a context that's highly innovative, potentially highly profitable, and also highly competitive, it does make a lot of sense for space tech companies to seek patent rights to protect the market share they invested for. And in my practice up to the Moonshot program, I have to say, I rarely came across space-related technology, and participants drew my attention to treaties that allow countries to extend their jurisdiction into space. So for a patent agent, this begged the question, how does patent law fit into this? And I figured that if this was a blind spot for me, it might also be the case for other Canadian companies that are looking to enter the space industry. So as I explore the topic, I turned to Jay, who's a member of the Space Tech Practice Group at Aird McBurney, for him to draw insight from his practice for the benefit of our audience today. This is a topic that's quite dense and multifaceted. We came up with material that we think you'll find helpful. So Jay, over to you.
Thank you, Jérôme. Hi, everyone. I will talk about a number of aspects of this topic today. There is a lot of ground to cover, as Jérôme mentioned. So we'll deal briefly with why to secure IP in this area, and some of the basics of IP law, which some of you may know, some of you may not, but we'll focus on the areas that relate to IP and outer space. And then we'll touch on the treaties that relate to outer space, the Big Five. And then we'll go through some of the individual aspects of patent law in some of the common launch jurisdictions. We'll talk briefly about detecting and asserting infringement, and then the major point of this discussion is going to be strategies for securing IP. As we'll see, there are complications that can be present but there are ways to address them. We'll go through a couple of examples, and then we can have some Q&A. Depending on time, we may ask you to send questions. Feel free to send questions after the fact. We're happy to answer them. Okay, so there are a number of reasons for securing IP. They're all equally important. Some may be more important for some companies than others. Deterrence is the first one. A lot of companies, if they know that a technology is patented, they will simply steer away from it and look for an alternate solution. Sometimes it's out of, a sense of right. Sometimes they simply don't want the bad press. But a lot of companies will respect IP rights. As many of you probably know, valuation of a company is often impacted by the number of patents that it possesses. And so you can increase the value of a company by securing more IP. You're more interesting to investors, and it's not just IP in one country, but it may be around the world. In terms of bargaining, what winds up happening in many cases that we've seen is that companies will wind up incorporating solutions to problems that they have where they know there is a potential to be infringing others' IP. And if they don't have their own IP to protect their territory, they are alone in terms of infringement. So what winds up happening is two companies can believe that they potentially infringe each other's IP, and they'll leave each other alone because they understand that they're both in the same boat and they don't want to, nobody wants litigation. So it's a way of protecting your ground and also giving you a negotiating card. A fourth point that is very important is often when you're talking to a potential customer, you have to explain why your system is better than someone else's. And it's very difficult to do that if you are unable to disclose, the key aspect of your invention because you have no protection for it. So it's not always suitable to rely on it as a trade secret. It's not always suitable. It's often not suitable to simply rely on an NDA because if the NDA is breached, it's very difficult to assert your rights at that point, and you have no protection at that point anyway against others basically taking your invention. So at the end of the day, there is little other recourse if you don't have IP rights. It gives you something to work with, and if you don't have them, it's very difficult to protect your R&D. Okay, so a patent is essentially a bargain with the government of a particular country. So your side of the bargain is that you have to disclose the invention in enough detail to permit someone to make it, to practice it. And in return, you're given protection for that that invention for a period of time. Today, it's 20 years from the date that you filed the patent application. And or up to 20 years, because there are fees that you'll have to pay to keep it enforced. So the structure of a patent is, there are 3 parts to it. You have to describe the invention. It is in your best interest to describe it in a fair bit of detail and to give alternatives for each aspect of the invention. You want to cover as much ground as you can in terms of ways to approach, how you've solved the problem. The claims are what define the protection you get. So I liken them to a fence around territory that you are claiming as yours. Patents will have a number of claims that will get progressively narrower in terms of the protection that they give you. So a narrower claim is less broad. It doesn't cover as much ground, but it's also harder to invalidate. So there's value in having very broad claims, and there's also value in having narrower claims. The drawings are there to support both the description and the claims. They are there to illustrate the invention. And so that's the protection you get. It's a negotiating process with the patent office to ultimately arrive at the scope of the claims that you are granted. Patents are territorial, so you have to request a patent grant in each country that you want protection in. There's no such thing as a worldwide patent. People may have heard of something like that. It's not the case. It's really just a way of reserving your right to enter different countries. It's called a PCT. It's a way of reserving your right to enter different countries at a later date. But at this time, they've been discussing it for decades, but there is no worldwide patent at the moment. There are regional patents. Europe is probably the most famous. They've had a quasi-regional patent regime for decades. They've recently introduced something called the unitary patent, which is a true regional patent, in the sense that there is one law that governs it, and it's adjudicated in a single European court. There are various types of invention which are going to come into play later on in the discussion. There are apparatus and composition types of invention, where you have a device or a system that is the subject of the protection, or you've created a new kind of chemical composition. These are very physical. Other types of invention, however, are possible, such as methods of making an apparatus or a composition, which deal with processes, industrial processes. There are also methods of using an apparatus, for example, to achieve a certain goal. So method claims can be important. Every type of claim has its advantages and disadvantages. There are also software-based inventions. Over the years, different jurisdictions have taken different approaches on how to protect software. They recognize that it's important to do, but their laws have diverged in terms of how software-friendly they are. The US is probably the most friendly towards software-based inventions, and there's been a lot of case law on what kinds of inventions are patentable. Generally speaking, the more physicality you can introduce to an invention, the less likely you're going to run afoul of these types of laws. What activities are governed? So The activities that are governed are making, using, and selling, and the product. So what you are preventing someone from being able to do is to make the invention, to use the invention, or to sell the invention. These are also going to come up later on. Some jurisdictions prevent you from importing an invention into their jurisdiction. Some prevent it. They say that it's covered under patent law, and some will permit it. There is a law of temporary passage. So if a ship sails into the territorial waters, for example, of a country, most jurisdictions will say that if there was an invention aboard that ship, if there was a product aboard that ship that would otherwise infringe someone's patent, it's not considered an infringement. Okay. The treaties, the main treaties relating to outer space, the most important treaty is the Registration Convention. There are a number of others. They all have, well, they have varying effects on IP. The most important one is the Outer Space Treaty, is the Registration Convention. And then the Outer Space Treaty, we'll discuss them all very briefly. So the Registration Convention requires that space objects be registered with a particular country. So there are definitions that come into play. Who is a launching state? This is a state that launches or procures the launching of a space object. And also it's a state from whose territory a space object is launched. A space object itself is actually, funnily enough, poorly defined really in these treaties. This is the only treaty that really discusses it. It says that it includes the component parts of a space object as well as the launch vehicle for it, the booster, for example. The state of registry, as expected, is the state that the space object is registered to. So when there is a single launching state, it's straightforward. One moment. When there is a single launching state, it's straightforward. That state puts the space object on their registry, and as will be seen later, their jurisdiction is applicable. When there are two or more launching states, and this occurs regularly, they have to negotiate which state is going to be identified as the state of registry. So go. Now, the Outer Space Treaty is the treaty that stipulates that the state of registry retains jurisdiction over the space object and over the personnel relating to that space object while it's in outer space. So this is the treaty that is important in relation to IP rights. The Liability Convention simply states that any launching state bears liability for the effects of the space object. So for example, if the space object explodes, the launching states, not just the state of registry, but the launching states relating to that space object are liable for whatever damage it causes. The rescue agreement and the Moon Treaty are of somewhat lesser importance, but they essentially state that when astronauts are in distress or if they've had to make an emergency landing, all of these contracting states have a duty to help rescue them. The Moon Treaty mainly states that similar to the Outer Space Treaty, that the parties retain jurisdiction over their personnel, over their equipment. If they have an installation, it is in their jurisdiction. There's another agreement that comes into play. So when you have multiple countries that work together to create something like the ISS, they will have formal agreements amongst themselves. So the IGA, the ISS IGA is one such agreement. It's the main one that's in play today. And it basically states that it actually has provisions relating to IP. This was written in the 90s, and so there was more of an awareness at that point. So basically, the different countries that have brought in different elements to the ISS, a number of them have elements that belong to them. And so it essentially states that they have jurisdiction over those elements. They're registered to that country and they have jurisdiction over those elements. So if you're in a US module, whatever activities you carry out are effectively carried out in the US. So as mentioned before, the definition of a space object is actually not universally accepted for a variety of reasons. One is that it's not well defined in any of these treaties. Second of all, there is no consensus as to where outer space begins. So NASA uses a definition of 50 miles above sea level, whereas other countries use 100 kilometers. And so at this point, there has not been any litigation over this. And so it simply hasn't been adjudicated. Often when law is written, you wait for people to sue each other to find out what the law really means. A registrant is the same as the state of registry. It's simply the state to which a space object is registered to. You can look online. There's an online database of all space objects or many space objects. And that way you can see which state they're registered to. And a lot of resources are maintained by an organization called ANUSA, the UN Office for Outer Space Affairs, I believe it is. And they have a lot of resources. They have the text of all the treaties. They have this database, which you can search. There are links provided. We will provide you with the PowerPoint. And so these links are available. So as an example of registration, let's say a Canadian company builds a satellite and they procure the launch services from an American company, SpaceX, for example, to launch the satellite. So the satellite will be launched from the US using a booster from an American company. So Canada and the US both qualify as launching states for the satellite because the Canadian company procured the launch services and it's being launched from the US. And the same is true for the booster. So the US is not going to want to take responsibility for anything that happens, for the operation of the satellite, and Canada is not going to want to take responsibility for the booster. And so the way it is likely going to net out is that Canada will be the state of registry for the satellite, and the US will be the state of registry for the booster. So here we're going to talk about the law in various jurisdictions. We're going to talk about 7 jurisdictions that are common launching states. Interestingly enough, most of these jurisdictions are signatories to all of the treaties except the Moon Treaty. So the US is the one jurisdiction that has that's in the most mature state in terms of IP and outer space. They are the one jurisdiction that explicitly has a provision in their patent law. Their patent law is covered under 35 USC. And section 105 of that statute specifies that a space object that's registered to the US is considered US territory for patents. There is also case law that predates the introduction of that section of the statute that also supports this interpretation in any case. There's a case called Ex parte McKay, and it related to a process of obtaining oxygen from extraterrestrial materials, say on the Moon or Mars. And the Patent Appeal Board stated explicitly that Article 8 of the Outer Space Treaty was to be interpreted that a space object that's registered to the US falls under the jurisdiction of the US with respect to patents, and therefore that that is not a reason to hold that the patent shouldn't be valid, that the claims shouldn't extend to a process that's being used in outer space. There's another case called DECA Limited versus the United States related to a navigation system. It wasn't in relation to outer space, but it related to a system where signals were transferred between towers that were somewhere in the US proper, in the territory of the US, and the towers were on a ship that were in international waters. And it was determined that the ship was registered to the US, and therefore the entire patent, the entire invention was being practiced within the territory of the US. In relation to importing, the US explicitly states in section 271 of its statute, a patent statute, that importing a patented invention constitutes infringement, even if it was purchased in another country from the patentee. It also explicitly states that temporary presence is not considered infringement, but many of these jurisdictions require reciprocal recognition of this. In other words, we will not consider it an infringement in our country as long as you also would not consider our ship to infringe in your country if it held an invention. Europe, again, many European countries, it gets a little more complicated in Europe because European countries have their own individual laws. They are, again, signatories to all the treaties except the Moon Treaty. France signed the Moon Treaty, but never put it into its law. Also, Europe has the ESA, which is a non-governmental organization. They are permitted to basically take on the rights and obligations of these treaties. And so the ESA effectively is a party to all of the treaties itself as well. Their patent law is not explicitly applicable to outer space, except in the case of Germany and specifically in relation to the ISS, the IGA. For them, also importing patented invention would be considered infringement, but that's under the CPC specifically. Russia and China are similar. Their law is not explicitly applicable. They don't consider importing to constitute infringement. I think it's an economic issue for them. They really need to just be able to bring in gray market goods if it's less expensive. New Zealand is another launch territory, and it also, many countries, their patent law, the US and Germany are the only two that whose patent laws is, has any mention of IP and outer space. Japan, India, they are also launching states, and again, it's the same. None of them have explicitly applied their patent law to outer space. So, so patent law, where does it apply? It applies on Earth and in the airspace of a country. Again, only the US has explicitly applied it to space objects. However, via Article 8 of the Outer Space Treaty, there is at least grounds to support that IP law, patent law would apply to vehicles and outer space objects of countries that are registered to particular countries. Again, this has not been adjudicated yet. Nobody has asserted infringement in outer space that we know of. And so until that happens, it's, it remains not known. So patenting efforts, when you patent an invention, you have to make effort to have it be as clear as possible as to whether there's an infringement. The patent system best serves you when things are as black and white as possible. In terms of detecting infringement, it used to be easier to assert infringement. I will focus on the US here. A decade ago, you could simply state that a competitor infringed your patents without being very specific about it. Today, you have to provide some grounds to show that there is a plausible infringement. So you have to explain how it infringes, and you have to map, where you believe your claims are infringed, without having a perfect knowledge of it. Okay, so here's an important aspect of this talk. So how do you protect your invention when it relates to outer space? So apparatus and composition claims are the strongest types of claims because they are infringed when the invention is, quote unquote, sitting in the box. In other words, it doesn't have to be used. It doesn't have to be deployed. It is simply infringing as soon as it's made. And so these are claims that will be infringed before it ever reaches outer space. And so these are claims that are easier to enforce and also easier to detect infringement of. Methods of manufacture are also claims. We're talking about an object, a device that is manufactured and that is then launched into space. So as opposed to methods of manufacture of something in space, taking advantage of microgravity, that's not what's covered here. So methods of manufacture are also protectable if there is novelty in that process. And these are claims, again, that are going to be infringed here on Earth. You want to try to find infringement here on Earth where you can and look for strategies to do that. Methods of use. So these are the claims that can be the most difficult if the use occurs in outer space. So these have the most uncertainty and variability. So, when an object is only deployed, a satellite is deployed and then, say unfolded, and then it actually is put into use. That is the most difficult to enforce and to protect and to detect infringement of. So those claims are more difficult, and those are the claims, often there is a way around those types of claims. So a proper patent strategy would be to look for ways to protect an invention without resorting to those claims where it's possible. And often, even for a system where you are producing, let's say it's a 3D printer that actually only operates when it's in outer space, there are often ways to protect it using apparatus claims, for example. You should look for claims to a secondary use. So often these inventions are used in space, but they're also used in different applications here on Earth, let's say in an aircraft or even in an industrial setting. And so you look for ways to protect those aspects of the invention. Often it's those secondary uses that permit you to practice the invention in a profitable way so that you can then use it in a space-based application where it may not be as profitable until the market matures. And so those secondary use types of claims can be very important. And then you have to consider where you're going to protect the invention. As mentioned, patents are territorial. And so what you want to do is look to see, so we come back to make, use, and sell. you don't always have to focus on the use. You want to see where the companies are that are going to make similar devices to yours. And you're going to want to see where your customers are, because those are important jurisdictions as well as launching states. But those are important jurisdictions for you to secure protection in. So I'll give an example here of a company that develops a 3D printing system that's used for replacement parts. You don't want to ship up individual parts. You know, there are millions of parts or hundreds of thousands of parts on a space station, and you know, any one of them can break down and need replacement quickly. So you develop a new type of 3D printer that is used for preparing replacement parts, outputting replacement parts. So, so what you want, even though the printer is only going to be used in outer space, you want to try to find claims that would be infringed by the device itself sitting here on Earth before it's launched. So there may be features of the device that are tailored for the purpose of you know, operating in a microgravity environment. So you want claims that target those features, because those features are present in the device you know, as soon as it's made. The control system for the device, you know, may have various aspects to it in terms of its programming, in terms of you know, how it feeds or how it senses the material or how it senses its position or things like that. These are aspects of the device that can be protected while the device is sitting not turned on. And so this is a perfect type of claim that you can cover in your patent to protect the device while it sits on Earth. You can also secure protection for the use of the device, you know, as it operates in space. You can also secure protection for the products produced by the device, because they will potentially have properties that are different than, you know, the same product as it would be produced on Earth. But these are the types of claims that would be infringed in outer space. So you have to be careful about the jurisdiction that would apply to that device. Not so much who produced the device, but whose space station element it sits in. Another example would be where you have a system where there is communication between ground-based stations and a satellite, for example. So let's say you've developed a system where you have you know, higher you know, rates of data transmission or more efficient communication, less energy. And so you want to protect it. So because some of the system is in outer space and some of the system is on the ground, you need to approach it strategically. There may be aspects of the ground-based stations themselves, if you can characterize the claims in a way that focuses on those ground-based stations alone, and how they process or how they receive, how they transmit to the satellite, you may be able to you may be able to secure claims that relate solely to the ground-based stations. And so if you have protection for that, the satellite is sort of secondary to the discussion. There's infringement right here on Earth. Additionally, you can rely on the assertion that the satellite is registered to a particular country, and potentially the ground-based stations are also registered to the same country. And so you can assert that all of the activity is taking place within a single jurisdiction, similar to the DECA Limited case that we talked about. It's also worth mentioning NTP versus RIM that we may all be familiar with. That took place in the early to mid 2000s, where some of the process of communication actually explicitly took place outside of the jurisdiction of the US, and it was nonetheless held to be an infringement of a US patent. Interestingly enough, the method claims were not held to be an infringement because some of the steps of the method were carried out in Canada, but the system claims were held to be an infringement in spite of some of the steps occurring at relays in Canada. So the US in particular, in some instances will assert protection extraterritorially. So in conclusion, understand that space is becoming a more and more important market. And so the legal framework is in a state of evolution. At the moment, many countries recognize the importance of IP and not just physical property rights. And so their law is evolving as we speak. Right now, the US is the most advanced jurisdiction with respect to explicitly importing its patent law to space objects. It's important for you to consider the territories of the state of registry of you and of your competitors when you're securing IP, but it's possible to do. It's also possible to focus on infringement before reaching outer space, ideally, or after returning to Earth. So, for example, if you're making a composition that you are able to make while taking advantage of the microgravity environment, in outer space, the market for that product may be here on Earth. When you're talking about a composition as opposed to, say, replacement parts for a space station or a satellite, when you're talking about certain types of composition, you're achieving properties in that composition that you can't using industrial processes here on Earth. They're only achievable in space. But the market for them is here on Earth. So there is infringement that takes place here on Earth, and you want to look at where the customers are. So there are ways to secure useful protection for it. So every situation needs to be looked at individually, but in many situations, there are ways to secure useful protection where infringement can be detected and enforcement is more straightforward. So that's that's everything.
Thank you, Jay. That was a lot of ground covered in a short amount of time, but we do have enough runway to take some questions. We have one in the Q&A box. So in the space industry, how common is it for companies to protect their intellectual property through patents? Do they often choose alternative methods such as trade secrets to safeguard the technology, especially in defense-related innovations?
That's a good question. All we can say at this time is there are a lot of organizations that do secure IP. We have clients, of course, within our space tech group that secure IP, space-related IP. And of course, we see in the patent databases that there are a number of organizations that secure IP, the ESA themselves, NASA, also secure their own IP.
All right, thank you. So no additional questions so far. As mentioned, the recording will be made available online and the slides will be circulated. We hope that you found the content insightful, but also actionable based on the deployment and use of your technology, both as you map out your patent technology, but also as you look out for the patents of others. And on that note, thank you again, Jay. We do have a question coming in at the 11th hour, so let me see. Dave is working with the RCMP. He has the Security of Information Act protected space application. How does cross IP work between the US and Canada as the US DoD is involved?
I'm going to take that and respond offline if that's okay. I have not, I have worked in a limited way a long time ago with something like that, but we have others in our group that have dealt with this type of thing.
All right.
So I'm going to discuss it with them, and then I will.
Perfect.
He'll reach out. So that's great. If anyone has any questions, please feel free. We are here to educate, so we're happy to take any questions offline and respond to them.
Absolutely. Thank you again, Jay. And on that note, thank you all for joining and have a good rest of the day.